Hello everyone, how are you? This is our second recorded lecture video under legal research and writing. And today we will be talking about Supreme Court decisions or Supreme Court cases. Of course, you already know that the Supreme Court is the highest court in the Philippines and it has both original and appellate jurisdiction. It exercises original jurisdiction or those cases that are directly filed with the Supreme Court in the first instance without passing through the lower courts are cases affecting ambassadors and other public ministers and consuls, and over petitions for certiorari, prohibitions, mandamus, quo warranto, and habeas corpus. And these are specifically stated under Article 8, Section 5, Paragraph 1 of your Constitution. It also has original jurisdiction over writs of amparo, habeas data, and environmental writ of kalikasan. It exercises appellate jurisdiction to review, revise, reverse, and modify or affirm final judgment and orders of the lower courts in different cases. What are these cases? These are cases in which the constitutionality or the validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. It can also review, revise, reverse, modify, or affirm final judgment and orders of the lower courts in cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto, or those cases in which the jurisdiction of any lower court is an issue, all criminal cases in which the penalty imposed is reclusion perpetua or higher, and lastly, all cases in which only an error or question of law is involved. And we must also remember that the Supreme Court has administrative supervision over all courts and court personnel, as particularly stated in Article 8, Section 6, and it exercises this power through the office of the court administrator. So what does a Supreme Court case look like? By now, since you have already started your first year in law school, you must have seen this kind of cases, particularly in lawphil. So this is how a Supreme Court case looks like. So the title of this case is Grace J. Garcia or Grace J. Garcia Rescio versus Frederick A. Rescio. Before we go to this case, let us first read the digest. Perhaps you have read this in your persons and family relations subject. So we have Garcia Rescio versus Rescio, October 2, 2002. What happened in this case? When we talk about what happened in the case, we are actually referring to the facts of the case. Here, Frederick A. Rescio, a Filipino, was married to Edita Samson, an Australian citizen, in Malabon, Rizal on March 1, 1987. They lived as husband and wife in Australia. On May 18, 1989, their marriage was dissolved by a divorce decree issued by an Australian family court. Hence, on January 12, 1994, Frederick married Grace J. Garcia in Cabanatuan City. Since October 22, 1995, the couple lived separately without prior judicial dissolution of their marriage. Their conjugal assets were divided on May 16, 1996 in accordance with their statutory declarations secured in Australia. Grace now filed a complaint for declaration of nullity of marriage on the ground of bigamy. Since bigamy is also a ground for nullity of marriage, she filed this on March 3, 1998, claiming that she only learned of Frederick's marriage with Edita Samson in November 1997. So the issue in this case is whether or not the divorce decree submitted by Frederick Rescio is admissible as evidence to prove his legal capacity to marry petitioner and absolve him in the case of bigamy. What did the court say? It was held that the nullity of Frederick's marriage with Edita, as shown by the divorce decree issued, was valid and recognized in the Philippines since the respondent is a naturalized Australian. However, it does not prove respondent's legal capacity to marry petitioner. The decree, being a foreign document, was inadmissible to court because it was not authenticated by the consul or the embassy of the country where it will be used. What else did the court say? A document may be proven as an official record of a foreign country by either an official publication, attested by the officer having legal custody of the document. If the record is not kept in the Philippines, such copy must be accompanied by a certificate issued by the proper Philippine diplomatic or consular officer stationed in the foreign country in which the record is kept, and it must be authenticated by the seal of his office. Hence, the court ordered the RTC to remand trial in the purpose of submitting evidence that Crescio was legally capacitated to marry Garcia in 1994. Otherwise, declare the marriage null and void on the ground of bigamy for having established two subsisting marriages. As you can see, if you are already very familiar with the case, when you read the case digest, it is already very easy to understand. How do you study a certain case? Some students will look for the digest first and then study the full text and then read the digest again as a review. What will I recommend? You always ask the question to yourself. You please yourself as to how easily you understand the case based on different strategies. So you try different strategy. You may first read the full text and then read the digest, or you may read the digest first and the full text, and then as a way of review, you read the case digest. When I was a law student, it is very difficult for me to determine the issue of the case. And I think it is very difficult to spot the issue of a certain case if you are still a first-year student. That is why it works a lot for me if I read the digest first. But remember, a certain case may have different issues. So how will you know as to which issue you're going to focus? You go back to the syllabus of your teacher and check which topic did the case, and check as to which topic does the case belong. Now, in answering the issues involved in the case, I find it really very difficult using the word whether or not. So this time, I will show to you my strategy when I was still a student. I did this when I was in first year until fourth year, so that it would be very easy for me to understand the legal dispute of the case that I am reading. How does the court state a certain issue? It can be whether the divorce decree submitted by Rederick Crescio is admissible as evidence to prove his legal capacity to marry petitioner and absolve him of bigamy, or it can also be whether or not the divorce decree submitted by Rederick Crescio is admissible as evidence to prove his legal capacity to marry petitioner and absolve him of bigamy. How do I write my case digest? Of course, I cannot digest all the cases given to me by my professor, so I always search the net. In fact, I have different subscription of different websites that will provide me good case digest. So I always rewrite the issue so that it would be easier for me to understand the case. How do I rewrite the issue? Instead of writing whether or not, I use is, or I convert it into a question. So now, the issue, for me to easily understand it, becomes, is the divorce decree submitted by Rederick Crescio admissible as evidence to prove his legal capacity to marry petitioner and absolve him of bigamy? Now, it is answerable by a yes or a no. So instead of starting the ruling of the case with the nullity of Rederick's marriage, I will first answer the issue of the case. Hence, this will now become, yes, the nullity of Rederick's marriage with Edita as shown by the divorce decree issued was valid and recognized in the Philippines. So that is how I strategize so that I can easily understand the case. Am I recommending this to you? Not really. As what I've said a while ago, you always please yourself. Know yourself better and know the learning strategy that will best suit your learning. Now, let us go back to how a certain Supreme Court case looks like. You may have seen this, but you still do not know the different parts of a Supreme Court case. Let us label this one by one. This one is actually the court giving the decision. Under the case of Grace Garcia Recio versus Rederick A. Recio, it is the Supreme Court of the Philippines. Next, GR number 138322, that is the case number. What does GR mean? It means General Registration. Then we have the date of the decision. This case was decided on August 2, 2001. Next, you will see the parties to the case. This is very obvious because you can see the word petitioner and respondents. And this is followed by the ponente. Who is the ponente? He is the justice assigned to decide the case. Next, you will see the applicable law of that certain case. However, this one is not always available. Some cases will go directly to the facts of the case. Here, we have the antecedent. what happened and where was the case filed. And it is followed by the facts of the case. This one is the previous ruling of the case. Well, obviously, this is the ruling of the regional trial court. Then you can see the issues. In some cases, the issues are properly labeled. Some are not. In here, there are 5 issues presented before the court. And this is the court's ruling. This case is a very good one because all the issues in the case are properly labeled. When you see the word wherefore, this is your clue that you are actually reading the dispositive portion. What is a dispositive portion? It is that part of a court decision which contains the judgment or resolution of the issues subject of the complaint or petition. It usually appears as the very last paragraph in a decision, as in petition is hereby dismissed for lack of merit. So I hope that you will not be very clueless as to the different parts of a Supreme Court case. Now let us go to the more technical part, which is the legal dispute. What is a legal dispute? When is there legal dispute? There is a legal dispute when one party complains of a violation of his right by another who, on the other hand, denies such violation. And when you are claiming a certain right, that right must be a legal right recognized by law. And this legal issue is actually akin to cause of action in a civil suit. What then are the significance of knowing the legal dispute? Since a legal dispute involves a violation of a right protected by law or which violation the law punishes, nothing less than the resolution of such could properly end it. Therefore, one of the significance of knowing the legal dispute is that the case is up for resolution. A legal dispute is at the heart of every case. It is the heart of every case, subject to legal writing, as the resolution of the legal dispute puts an end to litigation. And lastly, failure to identify and address the legal dispute would result in running around circles, contributing nothing to its final termination. If you do not know how to identify the legal issues, it would be difficult to find a way to solve or address the issue. You will be arguing on something that has nothing to do with solving the case. This is actually a futile attempt to end the litigation. Additionally, the legal dispute is actually a recast in the format of an issue. When you have a legal dispute and you've already identified it, therefore, you already have an issue. How do you recast the legal dispute in the format of an issue? Therefore, you write whether or not the tenant who fails to pay the monthly rents must leave the apartment unit, whether or not the debtor unjustly refuses to pay his debt under a promissory note that he issued in favor of the creditor, or whether or not the accused defrauded the complainant by selling a fake Rolex watch to him for the price of a genuine one. There is actually a reason why you write whether or not in a certain case. What is a legal dispute and the principal issue? Say for example, X, a building official, issues to the owner an occupancy permit for a building with inadequate fire exits. This one is the legal dispute. It is not in a form of question, but it only states plainly the dispute of the case. What is the dispute in this case? The complainant's claim that respondent building official issued to the owner an occupancy permit for a building with inadequate fire exits in violation of Section 3 of Republic Act 1319 and the respondent's denial of the claim. Then we go back to the definition of a legal dispute because we have emphasized a while ago that there must be a legal right recognized by law. Is this the legal dispute? Yes, because we are able to identify the law being violated. How do you state it now? Into a principal issue. Therefore, you add whether or not. How are you going to state it? Whether or not respondent building official issued the owner an occupancy permit covering a building with inadequate fire exits in violation of RA 3019. Changing this whether to a question is actually your choice. What is now the reason why our cases use the word whether or not? A legal dispute recast in the format of an issue becomes the principal issue in every case. How is this accomplished again? You are just only going to add the phrase whether or not. Whether or not the tenant fails to pay the monthly rentals yet refuses to leave his unit will now let the court decide in favor of the tenant or in favor of the renter. What is the importance of converting the legal dispute into a principal issue? The case will be decided for or against you based on the principal issues raised. The argument of the parties will be founded on and usually resolves around the principal issue. There will also be ease in crafting your argument in order to persuade your reader to accept your point or your view. And also, you get to save your time as you were able to identify the correct issue, considering that sometimes a particular problem poses several issues. So the strength of your arguments will be largely dependent on the relevance to the correct principal issue. Otherwise, your work will be useless. Again, what I am telling you, the correct format of a principal issue is to only add whether or not. This is the main reason why our cases in court starts with the words whether or not. Are you allowed to change it? Yes, you are allowed to change it only based on your personal preferences. But when we are going to do legal writing, you always add whether or not in converting your legal dispute into a principal issue.